The judiciary in India. The judiciary is the branch of government which interprets the constitution and applies the law. We need judiciary to punish those who violate laws, to resolve the disputes arising between people or organizations. Role of judiciary. Judiciary in India resolves disputes that may arise between citizens and government, between two state governments, between centre and state governments. It interprets the constitution. It has the power of judicial review, that is, to declare a law null and void if it violates the provisions of the constitution. It protects the fundamental rights of the people. Branches of legal system. Our legal system deals with two types of law cases: civil law, criminal law. Civil law. Civil laws deal with the disputes arising between various individuals or organizations. For example, disputes over property, tenancy, purchase of goods, marriage, divorce, child custody, breach of contract, borrowing or lending money, etc. Criminal law. Criminal law deals with cases which are considered crimes against society and not just against an individual. Criminal laws generally prevent harm to the society and provide punishment for criminal offences like murders, kidnapping, ransom, dacoity, thefts, etc. The judicial system of India. The judicial system in India is like a pyramid. It is divided into 3 levels. At the top of the pyramid is the Supreme Court, the highest or the apex court of India. It is followed by high courts at the state level. At the lowest level, district level, there are district court and subordinate courts. Supreme Court, High Courts, District Courts, Civil Courts, Revenue Courts, Criminal Courts. In India, we have an integrated judicial system. It implies that the decisions made by higher courts are binding on the lower courts. If a person is not satisfied by the judgment of a court, he or she can make an appeal to the next higher court. The Supreme Court. The Supreme Court of India came into existence on 26th of January 1950. It is located in New Delhi, the capital of India. It is the highest court of law in the Indian judicial system. The decisions made by the Supreme Court are binding on all the courts of our country. The decisions of the Supreme Court cannot be challenged in any other court in India. Composition. The Supreme Court is presided by the Chief Justice of India, who heads the proceedings of the court. It has the current strength of 31 judges. The Chief Justice is appointed by the President of India on advice of Council of Ministers. The other judges are appointed by the President of India on the recommendations of the Chief Justice of India. Qualifications. To be eligible to be appointed as a judge of the Supreme Court, a person must be a citizen of India who has been A High Court judge for at least 5 years. A High Court advocate for at least 10 years. A distinguished jurist, that is, an expert in law, in the opinion of the President. Term. Once appointed, the Chief Justice and the judges of the Supreme Court remain in office till they are 65 years of age. A judge of the Supreme Court can be removed only by the President on the ground of proven misuse of office, misbehavior, or incapacity. The procedure of removing the Supreme Court judge is called impeachment. Powers and functions. The powers and functions of the Supreme Court include the different kinds of jurisdictions exercised by the courts in different kinds of cases. Original jurisdiction. The Supreme Court has original jurisdiction over cases which originate in the Supreme Court only and cannot be heard in any other court, such as cases that require an interpretation of the Constitution, disputes between the Union government and the government of one or more states, disputes between two states, disputes regarding violation of fundamental rights. Appellate jurisdiction. The Supreme Court hears appeals against the judgments given by the High Courts in both civil and criminal cases. The High Courts may sometimes refer some cases to the Supreme Court. In such cases, the decision of the Supreme Court is final and binding. Advisory jurisdiction. The Supreme Court has the power to advise the President on the constitutional issues when asked for. The advice of the Supreme Court is not binding on the President. The President may or may not follow the advice. Judicial review. The Supreme Court has the power to declare a law passed by the Parliament as null and void if it feels that the law violates the provisions of the Constitution. Court of Record. The Supreme Court functions as a court of record. The decisions of the Supreme Court in all the cases are recorded and printed. These are cited in lower courts as case law in various cases. High Courts. High Courts are the highest court of appeal at the state level. Generally, every state has a High Court. Some states may, however, share a High Court. At present, there are 24 High Courts in India. Composition. A High Court consists of a Chief Justice and other judges. The number of judges varies from state to state according to the size of the state and decided by the President. The Chief Justice of a High Court is appointed by the President in consultation with the Chief Justice of India and the Governor of that state. For appointing the judges of the High Court, the President consults the Chief Justice of India, the Governor of that state, and the Chief Justice of the High Court of that state. Eligibility. To be eligible to be a judge of the High Court, a person must be a citizen of India who has been a High Court advocate for at least 10 years, a holder of a judicial office in India for at least 10 years. Tenure. A judge of a High Court holds office till the age of 62 years. The procedure to remove a judge of a High Court is the same as that of a judge of the Supreme Court. Powers of the High Court. Original jurisdiction. The High Court has original jurisdiction over cases that involve violation of fundamental rights or election disputes arising in that state. Appellate jurisdiction. The High Court has appellate jurisdiction or the power to hear appeals in civil, criminal, and revenue cases against the judgments of a lower court in the state and review the judgment in the following cases. If a party to a dispute is not satisfied with the judgment of a lower court, it can make an appeal to the High Court of the state. An appeal can also be made to the High Court if a subordinate court gives death sentence to a convict. Supervisory jurisdiction. It supervises the functioning of the lower courts in the state. Power to issue writs. The High Court can issue writs to enforce fundamental rights as well as other legal rights of the people of the state. Court of Record. The High Court keeps a record of all the cases and their judgments to be cited in lower court as case law in various cases. The subordinate courts. Each state in India is divided into a number of districts. The courts at the district level and those below it are called subordinate courts. These courts hear both civil and criminal cases. At the district level, there are two types of courts. District Court. The court that hears civil cases at the district level are called district courts. Cases related to property, land, money transactions, will, marriage and divorce, etc. are called civil cases. The court of the district judge is the highest court for dealing with civil cases. Sessions Court. The court that hear criminal cases at the district level are called Sessions Court. Criminal cases include cases of robbery, dacoity, and murder, etc. The court of the session judge is the highest criminal court in a district. The criminal cases are also heard by a magistrate. Revenue Court. The revenue courts deal with cases related to land records of agricultural land and collection of revenue or rent. They assess and collect land revenues from agricultural land holders. At the tehsil level, that is, lowest level, land disputes are heard by the revenue officers called tehsildars. At the district level, such cases are heard by the district collector. The highest revenue court in a state is the Board of Revenue. Nyay Panchayats. Nyay Panchayats are set up to deal with minor civil and criminal cases at the village level. They help in solving minor cases quickly and without much expense. Nyay Panchayat can only impose small fines. They cannot send people to jail. Lok Adalats. Lok Adalats or people's courts have been set up by the government to provide speedy and inexpensive justice to the people. There is no court fee. In this Adalat, the disputing parties put forward their case without the help of advocates. The cases are solved by mutual understanding. A large number of cases are decided in a single day. The first Lok Adalat was held in Delhi in 1985, in which 150 cases were decided in one day. Public Interest Litigation (PIL). PIL has greatly simplified the legal process. Any individual or organization can file a PIL in the form of a letter to the High Court or the Supreme Court on behalf of the person or persons whose rights have been violated. PIL has helped to increase access to justice to a vast majority of people, especially the poor and the illiterate. Independence of judiciary. The framers of the Constitution have made judiciary in India independent of the legislature and the executive. Separation of power provided by the Constitution helps judiciary to make independent and impartial decisions. The executive and the legislature do not have much role in the appointment of judges. The removal of the judges has been made very difficult. The security of tenure enables judges to dispense justice without fear or favor.